Dred Scott decision, legal case in which the U.S. Supreme Court on March 6, 1857, ruled 7-2 that a slave, Dred Scott, who had resided in a free state and territory where slavery was prohibited, was not thereby entitled to his freedom, that African Americans were not and could never be citizens of the United States, and that the Missouri Compromise 1820, which had declared free all territories west of Missouri and north of latitude 36 degrees 30 feet, was unconstitutional. The decision added fuel to the sectional controversy and pushed the country closer to civil war. Among constitutional scholars, Scott v. Sanford is widely considered the worst decision ever rendered by the Supreme Court. It has been cited in particular as the most egregious example in the court's history of wrongly imposing a judicial solution on a political problem. A later Chief Justice, Charles Evans Hughes, famously characterized the decision as the court's great, self-inflicted wound. Dred Scott was a slave who was owned by John Emerson of Missouri. In 1833, Emerson undertook a series of moves as part of his service in the U.S. military. He took Scott from Missouri, a slave state, to Illinois, a free state, and finally into the Wisconsin Territory, a free territory. During this period, Scott met and married Harriet Robinson, who became part of the Emerson household. Emerson married in 1838, and in the early 1840s he and his wife returned with the Scotts to Missouri, where Emerson died in 1843. Scott reportedly attempted to purchase his freedom from Emerson's widow, who refused the sale. In 1846, with the help of anti-slavery lawyers, Harriet and Dred Scott filed individual lawsuits for their freedom in Missouri State Court in St. Louis on the grounds that their residence in a free state and a free territory had freed them from the bonds of slavery. It was later agreed that only Dred's case would move forward. The decision in that case would apply to Harriet's case as well. Although the case was long thought to have been unusual, historians later demonstrated that several hundred suits for freedom were filed by or on behalf of slaves in the decades before the Civil War. Scott vs. Emerson took years to be resolved. In 1850 the state court declared Scott free, but the verdict was reversed in 1852 by the Missouri Supreme Court, which thereby invalidated Missouri's long-standing doctrine of once free, always free. Emerson's widow then left Missouri and gave control of her late husband's estate to her brother, John F.A. Sanford, a resident of New York State. His last name was later incorrectly spelled Sanford on court documents. Because Sanford was not subject to suit in Missouri, Scott's lawyers filed a suit against him in U.S. District Federal Court, which was found in Sanford's favor. The case eventually reached the U.S. Supreme Court, which announced its decision in March 1857, just 2 days after the inauguration of Pres. James Buchanan. Chief Justice Roger Brooke Taney's opinion for the court was arguably the worst he ever wrote. He ignored precedent, distorted history, imposed a rigid rather than a flexible construction on the Constitution, ignored specific grants of power in the Constitution, and tortured meanings out of other, more obscure clauses. His logic on the citizenship issue was perhaps the most convoluted. He admitted that African Americans could be citizens of a particular state and that they might even be able to vote, as they in fact did in some states. But he argued that state citizenship had nothing to do with national citizenship and that African Americans could not sue in federal court because they could not be citizens of the United States. Scott's suit, therefore, should have been dismissed for lack of jurisdiction by the district court. On this point, however, Taney stood on shaky constitutional ground. If even one state considered an African American a citizen, then the Constitution required that all states, and by inference also the federal government, had to accord that person all privileges and immunities of citizens in the several states. Article 4, Section 2, which includes the right to sue in federal court. Furthermore, Article 3, which establishes the jurisdiction of the federal courts, does not mention national citizenship but rather declares that the judicial power shall extend, among other things, to controversies between citizens of different states, the so-called diversity jurisdiction. Regarding the question of Scott's freedom, Taney held that Scott could not claim to be free on the basis of his residence in Illinois or Wisconsin. Whatever status Scott might have had while in a free state or territory, he argued, once he had returned to Missouri his status depended entirely on local law, notwithstanding the doctrine of once free, always free. Taney would have been on reasonably strong ground had he limited himself to upholding the district court's decision based on the idea that status was to be determined by the states. Alternatively, he could have held that Scott was not entitled to sue Sanford in federal court on the basis of diversity of jurisdiction, because Missouri did not allow even free African Americans to be citizens. But Taney outraged much of the North by asserting that African Americans could never be citizens of the United States. The framers, in his view, did not regard African Americans as being among the people for whose benefit and protection the new government was founded, notwithstanding the perfectly general language of the Declaration of Independence and of the preamble to the Constitution. Two justices, John McLean of Ohio and Benjamin R. Curtis of Massachusetts, wrote devastating critiques of Taney's opinion. Curtis in particular undercut most of Taney's historical arguments, showing that African Americans had voted in a number of states at the founding. At the time of the ratification of the Articles of Confederation, he wrote, "Thus, Curtis argued, they were members of the nation and could not now be denied the right to claim citizenship. The Southern opinion upon the subject of Southern slavery, trumpeted one Georgia newspaper, is now the supreme law of the land, and opposition to it is, morally treason against the government." The view that Southern ideologues such as John C. Calhoun had been promoted for more than a decade, that the federal government had a positive, indeed a constitutional, obligation to defend slavery, had apparently triumphed. Dred Scott did, in fact, get his freedom, but not through the courts. After he and his wife were later bought by the Blow family, who had sold Scott to Emerson in the first place, they were freed in 1857. Scott died of tuberculosis in St. Louis the following year. Harriet Scott lived until June 1876, long enough to see the Civil War and the 13th Amendment 1865 abolish slavery in the United States.